In Texas, injury to the elderly isn't just another felony. It's a charge that carries serious weight, with penalties reaching up to 10 years in prison. That's why, when the judge carefully outlined the rights and consequences, it was clear this wasn't a slap on the wrist, but a pivotal moment in the case. Notice how quickly the court confirmed mental competency. That step shows the judge was making sure the accused fully understood the situation, both legally and factually, before moving forward.
All right, court is calling 2022 CR 8673, State of Texas versus Mariah Lopez. Could I have parties announced for the record for the state?
For the state.
Defense.
Anthony Cantrell for the defense.
Are you Miss Lopez? Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lopez, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it? You need to speak up.
Yes, ma'am.
All right, Ms. Lopez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand in count 3, you're being charged with injury to the elderly as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, state is proceeding on count 3. Punishment is to be assessed at 5 years in the prison. The state recommends community supervision. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of your agreement? State?
Your Honor, State 62, admit State.
No. Is that your agreement?
I'm sorry, yes, Your Honor.
Defense?
Yes,
Next,
Your
I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 5 years. There be a top evaluation, no contact with Consuelo Franco, and the BIPP program. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Now comes a moment of truth. The plea, she enters a no contest plea to the felony, which is a strategic legal move. It isn't an outright admission of guilt, but the court can still treat it as one when determining the sentence. What stands out here is the state's recommendation of community supervision. However, the affirmative finding of family violence shifts the entire landscape. That designation brings long-term consequences, including the loss of gun rights and potential involvement from Child Protective Services, making the outcome far more serious than at first.
Offense is charged in count 3. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State 6 admit State Exhibit 1 and all its attachments. No objections.
All right, state, if you have no witnesses, you can be excused to continue to confer.
Thank you, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
All right, why should I accept this plea?
Your Honor, my client's very remorseful for her actions. She regrets it. She's been incarcerated for at least 4 or 5 months now. She's had a lot of, she says almost a year. So,
all right, and
this was out of character for her. She regrets it.
Let's pause here for a moment. The defense claims the incident was out of character and points to possible mental health concerns. But then the big reveal drops. The defendant has schizophrenia. That single fact shifts the entire tone of the hearing. It raises a powerful question. Should mental illness play a role in reducing the severity of the sentence, or does accountability always come first? It's a tough balance and one worth reflecting.
So we'd ask the court to go forward with the plea agreement because I think also probation can give her other help that she might need.
So what, is there some mental health issues here?
I don't think there's
If I could, the victim did
If you
express-
announce,
this is Brittany Mitchell for the state.
yes.
The victim did indicate to our office that she has schizophrenia.
Oh, well, okay, that explains some things because I was not intending to follow this. All right, so do you have any children? So you're not going to be able to live at this residence or have contact with Consuelo Franco. So where would she be staying?
Well, I was going to ask the court to, she probably won't be staying there, but she does want to have no harmful or injurious contact with her grandmother.
No, that's not going to happen.
With the mother?
Does the mother want her living with her?
I don't know that answer.
All right, because sometimes people just throw out names that they assume that people want them living with her and they don't. All right, this is what the court is going to do. Court is going to sentence you to 5 years in prison, suspended and probated for 6 years. There's an affirmative finding of family violence, the BIPP course. There's to be no contact with Consuelo Franco. I want a MIC evaluation. How long will that take, probation?
In custody, Your Honor?
Yes.
3 to 4 weeks.
All right. So there's going to be MIC evaluation while in custody. Are you on any type of medications now?
Yes. Just thyroid medication?
All right. So,
No, not really.
all right. I want a mental health evaluation while in custody.
And this is where things get heavy. The judge spells out strict probation conditions. No contact with minors, no employment involving the elderly, mandatory mental health evaluations, regular drug testing, and even Zoom check-ins. In plain terms, the court is balancing two goals: protecting the public while also pushing the defendant toward rehabilitation. This isn't just about punishment. It's about oversight, structure, and accountability at every step. This is justice in action with safeguards built
By Zoom or in person. If Mick says she doesn't qualify, I'm going to run a referral to Center for Healthcare Services. I'm going to want field visits 2 times per month, and that's until the mental health issues are addressed. There's to be regular UAs, proof of employment or SSI within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no contact with minors or the elderly. Now, probation, if she's working at McDonald's or somewhere, then that contact is okay. But outside of work, there's to be no contact with elderly or minors or vulnerable people. $150 hours of community service restitution. Probation, is there anything else she needs? If it's determined that she's going to be on the MIC caseload or either a Center for Healthcare Services provider with the case manager, then those hours can be waived. Is there anything else, probation? Is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargaining agreement, because I followed the plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes.
And probation, also, if we can do a TAP evaluation in custody. All right, good luck to you.
Thank you.
Thank you.
Court is calling 2022 CR 8673, State of Texas versus Mariah.
Just when it seemed like the case was closed, another twist hits. A motion to revoke community supervision. In simple terms, she's accused of breaking probation. And that's no small matter. Missed drug tests, skipping intervention programs, and now facing a new assault charge while already on probation. These violations stack up fast, like falling dominoes. The question now is how the court will respond to this escalating pattern.
Hank Wilkins for the state, Your Honor.
Defense.
Peter Calderola for Ms. Lopez, Your Honor.
Are you Mariah Lopez?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Mariah Lopez who was placed on community supervision in 2022 CR 8673 for the offense of injury to an elderly on March 20th, 2023 for a term of 6 years? Is that you?
Yes.
State.
Violated condition number 1, on or about the 9th day of February 2024 in Bexar County, Texas, the defendant, Mariah Lopez, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated condition number 2, on or about the 19th day of January 2024 in Bexar County, Texas, the defendant, Mariah Lopez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 14G, on or about the 19th day of January 2024 in Bexar County, Texas, the defendant, Mariah Lopez, did then and there fail to register, attend a state-accredited battering, intervention, and prevention program with approved agency in violation of condition number 14G.
How do you plead to that? True or not true?
Not true.
All right. And with regards to the other violations,
Oh, I'm sorry, Judge. We waive and abandon the other violations alleged in the motion.
any objection?
No objection, Your Honor.
All right, State, you can call your first witness.
Your Honor, I call Deputy Casares.
Your Honor, and if I may, before we proceed, testimony, for the purposes of the record, there was a plea offer in this case, and it was against counsel's wishes.
Oh, no. If you are going to put on the record what the plea bargain agreement was.
I wasn't going to put the plea on, Your Honor. I understand you're not allowed to be privy to the plea.
Oh, okay.
Just that there was a plea offer made. I advised my client to take the offer. I thought it was a reasonable offer. There were some cases that were going to be disposed as part of that agreement. However, the client has rejected that offer.
Okay. All right. Do you wish to continue with this contested hearing? That's either yes or no. What's going to end up happening is the state has read the violations. You've said they are not true. So now the state is going to call witnesses. They're going to call this first witness. You can turn around. That's the witness at the back of the courtroom. They're going to come and testify. So do you still wish to plead with your pleas of not true? Or do you wish for the state to go forward with their case and call a witness?
I didn't know what else to do. I didn't know. I didn't know we were doing this. I'm sorry. I didn't.
Well, you were here yesterday and you knew we were doing an MTR and you didn't want to come from the jail. So it took us a while to get you to come from the jail. I had to sign an order for you to be brought over from the jail. So you were brought back today for a contested MTR hearing. What will happen in the hearing is the state is going to call their witnesses. If they present evidence and I find it true, then I will find it true. Then we'll go forward with whether or not I revoke your probation or not. So the question for you is, do you wish to continue with your plea of not true? Yes or no? All right, state, call your witness.
Your Honor, we call Sergeant Casares.
Good afternoon.
Hi, good afternoon.
All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, make sure you keep your voice up so the court reporter can hear. If you can state your name for the record.
Rosemary Casares.
All right, state.
Sergeant, how long have you been with BCSO?
12 years.
And are you a licensed peace officer?
Yes, sir.
As part of your duties, do you recognize what I've marked as State's Exhibit 1?
Yes, sir.
And how do you recognize it?
That's the video from our overhead camera there in South Tower booking.
Okay, and how do you, did you have an opportunity to view this?
I did review it, yes, sir.
Okay, and how do you know that you reviewed it?
I signed and dated.
Is this a fair and accurate copy of the recording that you accessed in regards to this case?
Yes, sir.
Okay. Your Honor, I offer State's Exhibit 1, which is this is for the assault.
Okay. No objection, Your Honor.
All right, State's Exhibit number 1 is admitted without objection.
Do you have permission to publish this, Your Honor?
Yes.
And so, aside from providing the video to the investigations part of BCSO, did you have other interaction with this case?
I interviewed both, and I'm in charge of booking, so I'm aware of the inmates that are in our section.
Okay, and so do you recognize the defendant?
Yes, I do.
And how do you recognize her?
She was one of the inmates in booking that day.
Okay, and was she involved in an altercation?
Yes, she was.
And what happened?
She was in line to be transferred to the main jail. She walked away from the line and just went straight to Latrell and started striking her.
Okay.
If there is no objection, I believe this is the question.
Judge, my objection is to her memory being refreshed and her reading.
All right, if that's a report, you can review it to refresh your memory.
Yeah, just
So State, what is the question?
Who was struck in that video?
Latrell Rebecca.
And who struck?
Oh, who was striking? Oh, Lopez, Mariah Lopez. I'm sorry.
And what was the date that this happened on?
February 10th, 2024.
Okay, and where did this happen?
South Tower booking.
Okay, and is that in Bexar County, Texas?
Yes, sir.
I pass the witness, Your Honor.
Any questions?
Sergeant, you were present that day at the jail,
Yes, sir.
and you have personal knowledge that Miss Lopez assaulted the allegedly assaulted that other inmate,
Yes, sir.
and so you don't know that if the other inmate maybe had said something to Miss Lopez to get her, to kind of aggravate her.
She wasn't near her.
So you don't know what their interactions were beforehand, do you?
I do.
Okay. No further questions, Judge.
All right,
No further questions.
is this witness excused or subject for recall?
Excuse me, State, Your Honor.
Right.
Excuse me.
All right, thank you. All right, so with regards to the violation of condition number 1, State has already presented evidence on violation of condition number 1. Is there any evidence, and of course, defense, you don't have to present any evidence. Is there any evidence you would like to present on violation of condition number 1?
None, Your Honor.
All right, with regards to violation condition number 1, the court is going to find violation of condition number 1 true. State, are you still proceeding with violations of 2 and 14G?
No, Your Honor, we'll waive those.
Any objection?
No objection, Your Honor.
All right, then the court will hear requests from each party. What would you like to see done with regards to the motion to revoke?
Your Honor, we're asking for the 5 years. The defendant made a bargain for deferred initially. She was unsuccessful on deferred. Her sentence was reformed for community supervision. She agreed to the 5 years. She didn't do great on community supervision. She picked up a new offense that brought her to the jail. And then once she was in the jail, she picked up another new offense. So, Your Honor, at this time, we're asking for the 5 years.
All right, defense, what are you requesting?
Judge, we're going to defer to the court.
You have no request?
I would allow Miss Lopez to testify. I believe she wants to make some announcements.
All right, you want to raise your right hand? Do you wish to say anything? If you do, you're going to be placed under the oath and you're going to be subject to this examination from the state.
And then comes a hammer. 5 years in state prison. The judge even denies a request for a lighter sentence. And the reasoning is clear. The defendant didn't just violate supervision. She racked up 2 new offenses, including one while already incarcerated. The takeaway here is simple. Deferred adjudication is a second chance. But if you waste it, you don't just go back to square one. You lose the clock altogether. Real talk. Should courts take such a hard stance? Or is this exactly what accountability is supposed to look like?
All right, this is what the court is going to do. The court is going to grant the motion Court will sentence you to 5 years in the prison. There's an affirmative finding of family violence, credit for any time served, and there's to be no contact with the complainant in this case. And in the assault case, what is the name of the complainant?
Latrell, Your Honor. Sorry. Rebecca Latrell. It's
All right, and there's to be no contact with Rebecca Latrell.
it's spelled.
All right, I'm showing you what's in the trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand?